Welcome to the Greater Burlington Partnership Conference on the CARES Act and its implications to HR operations. I want to take just a moment to remind everyone on this call that the entire partnership office is ready to assist you. We are just a phone call or an email away. You're not alone in this COVID crisis. We want to remind you that we are here to help. Please reach out to us. At the conclusion of this conference, attendees will be receiving a short survey. Please take a moment to complete it, as it will assist our efforts to be of help to you in the ahead. Our goal here today is to help you understand the HR implications under the new CARES Act. We have two panelists who will be presenting today. Just a housekeeping note, we will be taking questions at the end of the presentations, and you can use the text box to submit those questions. Michael Witt is the Division Administrator for Field Service with Iowa Workforce Development, and he oversees all Iowa workforce offices in our state. And also with us today is attorney Brent Ruther, who is a partner with Aspelmeyer, Fish, Power, Ingberg, and Helling PLC. His practice emphasis is in litigation in the areas of commercial, corporate, construction, insurance defense, employment, real estate, and landlord-tenant law. So thank you to both Michael and Brent for joining us this morning. And I believe that we are going to begin with Mike, who will provide us with an overview of the new unemployment issues as it relates to the CARES Act. Michael.
Hi, Della. Can you hear me okay?
We can hear you. Okay,
great. I appreciate everybody's time and invitation to speak for a few minutes today and help to the best of my ability. Just wanted to go over several items related to the CARES Act, but wanted to start with a couple quick things to remind employers on the line. When you visit our iowaworkforcedevelopment.gov website homepage, a couple of things for employers. If you're out there seeking and filling positions or seeking temporary help, there's a couple of options if you're not already aware. When you visit our homepage and you scroll down just a tinge, you'll see a box for employers who are listing options for temporary job opportunities. And if you click on that link to open up the page that lists all of those employers, down towards the bottom is a sentence where if you have those temporary job opportunities and you want to get the word out, there's a sentence that asks you to send some specific information to an email address, and our folks in communication will put up your company's name, a website link if it's to a job bank, or if you've got certain individuals that those job seekers will want to contact for those openings, we can list you on that site as well as a reminder that our state job bank portal, iowaworks.gov, has been getting a lot of traffic from job seekers across the state looking for opportunities, whether it be temporary or full-time. So if you have not investigated iowaworks.gov in posting some of your job openings, please do that, because there's a lot of individuals that are using that site, looking for jobs, developing their resumes, and using the tools that are within that site. To go over a couple of the CARES Act unemployment options that are out there, really the best place for employers and for individuals to start with is on our homepage, iowaworkforcedevelopment.gov, is a tab at the top called COVID-19. And when you click on that tab, you're going to see a lot of different information. Just below the banners at the top are the links to the 3 CARES Act unemployment assistance programs, and I'll cover those briefly here in a second. And as you scroll down the page, you're going to see a lot of other resources, both for employers and for individuals. We have pages developed for FAQs, both for employers and for individuals, with scenario questions and answers that we are getting, and we're updating those 2 pages often. There's information about voluntary shared work program for those employers that may be an assistance to. And then we have videos for individuals, both in English and in other languages. If they've never filed for unemployment before and they're nervous about how to do it, or if they've done it right, we've got videos that they can watch that walks them through step by step, page by page, what information goes where. And then down near the bottom of the page, we have some other webinars. Usually every week we are holding 2 to 3 different webinars, both for employers and for job seekers, and we update those webinar links at the bottom of the page throughout the week. In fact, the last employer webinar, which was 2 days ago on April 7th, that link is live. And during that April 7th webinar, we had a couple of special guests, both from the banking industry, to talk about things like the Paycheck Protection Program and some of the other SBA employer-related CARES Act programs. We had some attorneys and some other individuals from the banking industry talking about those programs. So, you know, if you're ever needing the most up-to-date information that we have, that COVID-19 tab on our main website is really the place to start and begin to look for the most updated information. So I just wanted to briefly touch on the 3 CARES Act unemployment pieces, and I'll apologize up front for giving you acronyms. That's something that government does really well, but so the first one is the PUA, or the Pandemic Unemployment Assistance. And when you click on that page, it really goes into detail about what the PUA, or Pandemic Unemployment Assistance Program, is all about, the eligibility. That one for us in Iowa is a big one because that is the program that assists folks who are self-employed, independent contractors, 1099, or folks that have insufficient work history to be eligible for a regular unemployment claim. That is the program that assists those types of individuals. And so if you know of or have individuals that fall into that category, please direct them to the PUA page on our website, because it really goes into detail about the program, about how they need to file, the steps at the bottom. There's three steps they have to walk through, from filing their claim and submitting proof of income, and what those options of proof of income are, so that we can determine what their weekly benefit would be and be able to process their claim. The second one that is part of the CARES Act, probably the one that we get the most questions on, is the FPUC, the Federal Pandemic Unemployment Compensation Program, which is about the additional $600 federal payment that folks who qualify for existing unemployment benefits would be eligible to receive the $600 on top of their normal weekly benefit amount. That page explains in detail when it became effective, March 29th, which is the week ending April 4th. And currently the FPUC, or the Federal Pandemic Compensation, the $600, ends on July 25th. We really don't know if that's going to get extended, but currently it ends on the 25th. And as you walk down that page, it really goes into detail about the eligibility for that extra $600. Basically, an individual needs to be eligible for one of the CARES Act or regular unemployment claims before that they could receive that additional $600. And so that page is all about the $600 piece. And then the third page is about the Pandemic Emergency Unemployment Compensation, which is labeled PEUC. Some folks may remember about 10 years or so ago, our state had an EUC, or an extended unemployment compensation program in place because of some disasters that we had in Iowa. And this one, as part of the CARES Act, put a P in the front, PEUC, and that basically allows for an additional 13 weeks of unemployment. If they've exhausted all other unemployment avenues, they could be eligible for additional weeks of extended unemployment after they've exhausted. And so really, those are the three areas of unemployment that we are currently working through. When the president signed the CARES Act, I think it's been now a couple of weeks ago, those programs have to go through the Department of Labor first. And so all states had been waiting for guidance from the Department of Labor. Much of that initial guidance came out late last week, Thursday, Friday, and then actually into this past weekend, and continues to actually come to us throughout these days to help states figure out how those programs need to be administered, some of the rules and laws around them. And I think Iowa is in a good place. We are working very hard to make sure that the extra 600, when that switch goes on, hopefully by the end of next week, I think is our goal or time frame that we're shooting for, that those payments are coming out to the right folks in the right way, including all of the other CARES Act unemployment situations that folks might be in. Things are going pretty smooth, and we're getting those claims processed. The folks that are eligible for the self-employed or the independent contractors, we are working through all of those documents that folks are sending to us to determine their eligibility, and working very hard to hopefully as well next week begin to pay out to those folks as well. But for any updates, for any, hopefully folks are connected to the press releases from us that are coming out. We post those on our iowaworkforcedevelopment.gov site as well, with any new updates that come out. And I think that was the most, or what I wanted to share this morning.
Thank you, Mike. That is a very good initial overview. In a few minutes, we're going to go into presenting some specific scenarios for you to respond to, and also we'll be taking questions. I do want to remind everyone on the call that the links that Mike referenced, as well as other resources, that can also all be found on the greaterburlington.com website under COVID response information. So that's another place you can go to. At this time, we're going to move on to our attorney, Brent Ruther, who's going to talk about important things folks need to know about employer and employee rights under the CARES Act. Brent.
Well, okay, so I'm honored to be here, but here's the problem with these two acts, as I see it, and as I found out. They expand unemployment, and they expand the Small Business Act, and they expand the FMLA. And the problem is all of those laws and regulations have been developed over many, many years, and as hard as they try, lawmakers don't always write in clear terms, and they can't possibly expect all scenarios and write those into the law. So we have bodies of case law that interpret those, and we don't have that with these acts. I mean, they were written and enacted in such a quick fashion that there are a lot of questions. You know, what do we do? And are we going to get sued if we do this or don't do that? So it's really hard for your attorney, for me, for attorneys in general, at this point, without having fact-based scenarios that have been determined in the courts, to give complete or, advice that We can say, look, this is the way it is. I have been referring, I see a lot of bankers and I see a lot of accountants. And of course, we've got Mike here, and I've been deferring to them a lot, simply because, one, with the unemployment compensation, it's an issue of, do they qualify? Does the employee qualify? Should we lay them off so they can qualify? It depends on what your business, whether your business was completely shut down by the government proclamation, whether you're partially shut down, whether the state of Iowa, and I'm not even sure Mike can answer this, if they have the Payroll Sharing Act or sharing provisions in place. Then you've also got, this seminar is supposed to be on the CARES Act, but I mean, necessarily a couple of scenarios that were put forth to talk about today involve the FFCRA, which is the expansion of family medical leave. And that's a big issue for employers right now. And then where I think a lot of litigation is going to come out, and I understand from reading materials, there's been a lot of issues with the lenders, and how do we, the qualification is a small business, and then pushing those loans through for employers. And I've even heard of, the biggest problem there is going to be fraud. I mean, there's a lot of people trying to grab money right now that don't necessarily qualify. And I think the lenders are kind of in a position where they're not getting perfect guidance from the Small Business Administration, and a lot of people are being pushed to the side where they should be qualifying for these loans. So as a lawyer, that's how we speak. I mean, I can't answer questions exactly, and nothing I can say here today would be legal advice, but I think going through the scenarios, I have some opinions on them. It's difficult, particularly when you're in a business where you haven't necessarily been shut down, because in those cases, I think the main issue is to get the employees to the unemployment office, and hopefully they qualify and get paid. But if you've got partial, if you don't have a government shutdown, if you haven't been completely shut down as a non-essential business, but you can't make payroll, what do you do in that situation? That's the most difficult thing for employers right now. And how can I possibly afford to pay out under the FFCRA the expanded benefits that are being allowed? And the employer has to make the determination whether a person qualifies. So it's unprecedented for sure. And it's necessary because we're in a very, very difficult time. But I see the issues are going to start arising as it gets applied, and the people who really have the knowledge in these situations are state agencies like Mike's agency, the accountants who can help you with the tax credits, the possible payroll tax credits, and the lenders who have to deal with these applications that I understand some of them can't even get them through, and they didn't get guidance. Mike talked about the unemployment offices not getting guidance for a period of time. Well, I mean, I don't know that the lenders, and I know some of them are on here, have gotten very good guidance or complete guidance from the government on how to deal with these requests for loans. So I'm going to do the best I can to answer questions as they come up, but it's a difficult time right now for employers, and particularly when there is no, like I said, there's no development of this law yet, and there may never be, because there will be claims afterwards. But at this point, there's no time to have claims filed, and the court system is essentially shut down to have judges' rulings or judges' interpretations on certain fact scenarios, and whether the employer or the lender or employment offices did things right or not in the eyes of the court. So that's my spiel for right now.
Okay, well, that's an excellent start. And I think it's important to emphasize that there is a lot that is unknown and that we're all doing the best that we can. So with that, let me give you a few scenarios, and Mike and Brent, feel free to just kind of jump in as you feel it lines up with your area of expertise. So for example, a local business is either deemed essential, whether that be if the governor of Iowa actually goes that direction, or if we just think about the businesses that are not on the list of mandated closings by the governor. And so those businesses are up and operational, and they're meeting the demands of their industry. Maybe they have a few employees that have indicated that they're not ill, but they're afraid of catching the virus, and they've heard that they'll make more money with unemployment if they stay home. What is your advice to employers? How do they handle that?
Oh, this is Mike. I mean, I'm happy to help to the best of my ability. And that question really directs back to one of the FAQ pages for job seekers, for individuals on our site. And we're, for those businesses that are still up and running, they have not been impacted where they've had to lay off or close or temporarily close. They're still operational. We are really strongly, and you can see that on most of our pages, letting individuals know that, they can't just quit their job because they feel like they will earn more on unemployment. That's against unemployment law. And those cases, as they come up, would be adjudicated as any normal unemployment time would be. And if you read some of the FAQs that are on our pages, in fact, there's a question and answer that is exactly to that one, where a person would not be eligible if they quit their job just because of fear. Unemployment is for those folks who've lost their job through no fault of their own. And so that's how I would answer that question.
Brent, do you have anything to add?
No, I mean, I agree with that. That's a situation that has come up. I do know, I'm pretty sure in Illinois, there's already maybe been a decision where somebody had the fear, and what they, the claim that they made was the employer wasn't, protecting the employees the way they should. They didn't take any steps. So they claim that their fear was good cause based on the employer, and they didn't get their unemployment. I mean, you have to qualify in order to get it. And I believe, Mike can correct me if I'm wrong, there's some pretty harsh penalties for people who are trying to do exactly that. They see the $600 extra until July and partial payment, and they realize that they would make more money. And so they quit their job and attempt to get it. And I tell employers that, well, we need to defer to the unemployment office, and they will weed those out. I mean, that's one of those deferral things.
Okay.
Talk to your lender, talk to your accountant, and talk to your unemployment office.
Okay.
Yeah, and I would just add on the FAQ for workers, question 15 addresses that. If they voluntarily quit or refuse to work or refuse to return to work, that they would not be eligible. And a lot of the questions also direct individuals to reach back out to their employer to talk through potential telecommuting, if that's possible, sick leave, PTO, FMLA, other paid options in those types of cases where they fear or have a family member with a health condition, or they think they've been exposed and there's not a layoff type situation, to reach back out to the employer and talk through those scenarios of what paid leave is available.
Okay, sounds like that frequently asked questions is an important resource for folks to return to time and time again. Gentlemen, let me throw out another scenario for you. Let's say a medium-sized restaurant business with multiple locations. I could even give you some numbers. Let's say they have 32 full-time employees and about half that number in part-time. And they have 5 employees who've lost access to daycare services, and another 6 that have got kids at home due to school closure. What is the business required or responsible to do for these employees who are saying they're not available to come to work because of these type of situations?
Well, I would say you're welcome to go ahead first if you want.
Well, this is the most difficult scenario we were presented with, I think, because it involves both unemployment and it involves the new expanded family medical leave. A restaurant is not an essential business, but as we know, a lot of them are staying open to do carry out. So you're going to have a situation where potentially you can lay off some people or have to lay off some people. You could also do a shared work program where they get a pro rata piece of their unemployment with the idea they come back. You've also got the question of whether or not you should go ahead and go get a payroll protection loan, if those are even available right now. And then the question always comes up. I mean, it's really a business decision, but you have to do it right. Where, well, here's my bottom line. If I pay, allow these people, because that in that situation, an employee where the business has not been shut down would likely qualify for the FFCRA, for the expanded family medical leave, which includes two weeks of paid leave at a certain rate for certain scenarios, and then expanded medical leave. And some business can't afford that. So then is the question in that situation, I don't know the answer. I'm not going to, give a solid answer here on a webinar, but the question that's going to come up is if the person is an employee that's going to continue to work or can continue to work and you're going to stay open, and this is whether it's a restaurant or not, I mean, it's a little different, but if they go ahead and apply for the FFCRA relief and then the employer determines that they can't afford that and they decide to lay off, what's going to be the ramification under that? I believe that act provides immunity from civil suits, but there are still Department of Labor ramifications if you violate that act. It's a retaliation claim. So that's one of the more common things that's been coming up. I mean, how do we keep our employees fed and under a roof because we care about them, but how do we deal with, well, we've got some employees that want to stay here and can stay here and they don't have children at home, but continue to pay them while we're paying other people under the various acts. So that's a really difficult situation, and my advice there is to talk to an attorney that's well versed in FMLA, but that is the way you can do it, though. I mean, you can pay them if you can afford it. You can pay those employees who are off because of the sick child or the school closure with benefits under the FFCRA and obtain credits for that, and then try to continue business.
And I'll also share, because I know a lot of scenarios are similar. Employers, when an individual files, whether you know it or not, the employer is going to get a notice of those individuals, and you have the ability to, just like you would in any normal time, to send back in that notice so that there is some type of adjudication or fact finding to look at, the situation and the scenario. So, employers have the ability to do that if they get that notice and they see that an individual has filed and they're not quite sure that they really should be eligible. They can contest that and have a fact-finding hearing and a decision made at some point. That's also an option.
Okay, thank you, gentlemen. I have another question that I think you're going to say, yep, that one is one you've heard before, but I know many folks on this call are interested in the answer. So let's say that a local employer has an employee who is ill, cold, flu-like symptoms. The employee has stayed home and has called their doctor, and the hospital and or local provider won't necessarily provide them with a COVID-19 test, but does tell the employee they should stay home, ride it out, quarantine themselves for 14 days to be on the safe side, and call the doctor or hospital if their condition worsens. From an employer standpoint, what is required, since these employees do not necessarily have a confirmed COVID case, and they may not have actually been seen by a physician in person? There's a lot of telemedicine happening now. What is the employer's responsibility?
Well, I'll jump in maybe before the attorney, but I think, again, that goes back to maybe one of the original scenarios. You know, it really depends on that employer situation. Are they in a situation where their business is impacted? Do they have layoffs, reduced hours, shutdowns and things going on? Or are they still operational and have work for their employees? And so, you know, if, like we tell folks on our FAQs, if the doctor is asking you to stay home, if you're feeling ill, if the employer has the right to have a person stay home for that incubation period or whatever that is, but to make sure that you're looking at all paid time off resources, sick time, FMLA, other things, if you're not in that layoff status. That's how I would answer that question.
Yes, and I believe the scenario is assuming that worker has work to do and could report to work, but is asking for 14 days off because of potential fear of COVID, whether they're confirmed COVID or not. Brent, would you have anything to add?
Sure. With my caveat, there's a possibility and likelihood that if it was a healthcare professional that diagnosed them or didn't diagnose them, but quarantined them because of symptoms, then I believe that they qualify under the FFCRA for the expanded family medical leave. And you've got to look at how to pay that if they apply for it and qualify for it. Again, that's my conservative view on it for purposes of a teleconference. But that my understanding is that is one of the qualifying reasons for someone to get the expanded Family Medical Leave Act benefits. That's not to say that's what an employer should do. And I mean, again, it's just such a weird period because nobody's trying to defraud the system, or there are people trying to defraud the system, but most of us as employers, because I am one, and all the employers I've talked to truly care about their employees and want to keep them healthy and with paychecks. So, in that situation, if the employee can't telecommute, because if they can telecommute, then they don't qualify for the expanded leave, you just keep paying them. If they can't telecommute, then you've got to look at exactly what the diagnosis was or the concern, figure out whether it was an actual, a call into a clinic, and the doctor, I think the telemedicine is qualifying now, then they would probably qualify for the expanded family medical leave. And if you can do that, do that. If you can't do that, then I would suggest, again, digging more into it with a FMLA lawyer that can determine what your best scenario is. I mean, a layoff would be possible, and that person could get the unemployment benefits. You're not charged for it, and possibly get the unemployment benefits. That's up to Mike's organization, but potentially could, and then you can bring them back when they're better, because that would be a pretty short layoff. If they're a 2-week out type of thing where they've just got symptoms and they don't continue to develop, as I understand the medicine, they could probably come back to work at some point. The first thing I say to people is, do your best to have people telecommute. I mean, if it's possible at all, do that and monitor hours.
Sure. Unfortunately, in a significant number of our employers' situations, telecommuting is not an option. Manufacturing, grocery, and other similar services. So we need those folks actually at work. What if an employer has granted that time off to an employee who's claimed illness, but then there is some citing of the employee out and about, not looking or acting very sick? I saw that question pop up, and we're going to move to questions from our listeners here in just a minute, but because that just came across the scene and we're on this topic, I wanted to just go ahead and pull on that thread.
Well, I mean, again, this is one of those questions that they can't write into the law. They write the law, and then fact scenarios come up, and two parties disagree, and they go to a lawsuit, and then the judges decide. My understanding of the way the law is written, the FFRCA, CRA, if the doctor says that this person should not come to work because of COVID-19 symptoms, or if they have COVID-19 symptoms and are currently seeking a medical diagnosis or a test, I think that's one of the two qualifying situations. That's not it doesn't necessarily mean the employee can't go to the grocery store. Quarantine, I mean, if it's a single mother or somebody that absolutely has no other support that can't get groceries, then they've got to go to the grocery store at some point. So you've got to kind of be careful with that as an employer. They would probably qualify for it. And just because they're out and about doesn't mean that they're not still a qualifying person. Something you want to go talk to your lawyer about, because I've seen situations like that where people are feigning the symptoms, and they can call into the telemedicine because the healthcare system is overwhelmed right now, and they're told by the doctor that they need to stay home. And then the flip side to that is, we don't want people coming in that have the symptoms, because we've got to protect everybody else to keep our business up and running. So I don't want to be cynical about it, because it's a bad situation all around, but I understand the question from the employer on the chat, and it's a concern, because I've seen it happen where the person absolutely should not have gotten the leave and shouldn't have gotten the payment. They should have been at work, but we have to be careful with that. It's best if you can afford it and survive with the assistance that's out there, to err on the side of caution in this situation, because if you have other employees that get sick because of it, you don't want that to happen.
Excuse me. Okay. I'm going to give one last scenario, and then we're going to open it up for Jeremy Hess, our Director of Economic Development, to go through the questions that we've been receiving via the chat. So let's move to a small business example. If we have a small retailer or restaurant or some other kind of small business that due to COVID, they just had to close down altogether. They're not operating in any sense. They are still paying their employees, but it's becoming more and more financially difficult for them to do that. Should they furlough these employees and take advantage of some of the programs available, the PPE, the EIDL, or should they just lay them off, allow the employees to receive the unemployment, keeping in mind some anxiety about that extra $600 a week, and then hope that they can bring them back on board once this has cleared? Mike?
Well, if the second, I'm not sure that I can really give my opinion on which way they should go. I can, if they decide to go the route of layoff, obviously those people would be eligible to file, and more than likely, depending on their individual situation, could qualify for unemployment and or the extra $600. But I'm not sure that I can give my opinion on whether they should do one or the other. maybe I'll let our attorney share his opinion on that.
And it's another one of those that I don't know. I mean, a lot of these are business decisions. I mean, do you lay people off and bring them back? Do you, in that situation, I mean, if it's more financially beneficial in order to keep your business open for when we come out of this and bring everybody back, to do a furlough and take advantage of the partial Payroll Protection Act loans, then I think an employer has to look into that. I mean, I've told employers, what you need to do early on is talk to your tax accountant and make sure they understand all the credits and how they're applied for, and you have to do, and that whole scenario, and what financial effect would that have on me, and then talk to your lender and ask them, because I don't know. I mean, that part of it, I've just heard some nightmare stories, and I know there's bankers on here, maybe they can answer some questions, but I don't know what the time frame is with these payroll protection loans, and if it's too long of a time frame, do you have enough to cover until then? I mean, the best case scenario in that situation would be to furlough and allow people to continue to work some, and either do a work sharing thing with unemployment or get a payroll protection loan. But again, I don't know what's going on within the lender community and how easy these are. And there's a cap on the funding. I mean, it's I can't remember how much, $59 billion for those loans, and that's going to run out quick. I mean, I know around the country there's a lot of these things being handed out, and so rely on the other professionals that you have, the tax accountants and the lenders, to determine what's best for your business, and then go with that.
All right. Well, listen, I'm gonna throw out some questions, and for our audience out there, if you have a question, go ahead and put it in the chat, and I'll try and kind of weed through these and see if there's any trends that we can combine some questions. But one of the questions, Mike, might just be for you, is that employers are receiving notices of claims, and what are they to do with them? Are they supposed to, so they're getting notices of unemployment claims. So number one, what do they do with those? Number two, speak to a little bit, I've read something about how premiums are not going to go up or because of this, or won't get charged back to the employer. Can you touch on both of those?
Well, employers are getting those notices like they would during any normal situation throughout the year, and so they have the ability to see their employees who has filed and what their weekly benefit is. And then again, as I mentioned earlier, if there's a situation or a scenario where an employer feels like there's an issue, they can contest, and that will go through that process with a fact finding and a final decision on whether the individual was eligible to file or not. Right now, I'm not sure that I can give you 100% on that last piece of the question. All of the charges for the CARES Act, the pandemic unemployment and those things, there's no chargebacks to the employer. There's no cost, including voluntary shared work right now. I don't know if that helps answer that second piece, but keep those documents that are coming. And then if you feel as you're going through them that there is a scenario where you're not comfortable with that situation, you can contest and let it go through the normal process.
Okay. All right. So I'm going to share a question here from my friend Lewis Morton. So an employee is receiving pay through FFCRA and the 80 hours have been paid out. Can they apply and receive unemployment?
So if there is, if there's no other form of paid leave, yes, they can apply. And again, once they apply, an eligibility determination will be made, and that individual will get a letter in the mail to let them know what their weekly benefit is, as well as the employer will get that. But I think I'm pretty sure the answer is if there's no other paid leave scenario, and if you're an employer that has, that's not in a layoff status or not laying people off or reducing hours, and there's no other paid leave capability, then they should file, yes.
Okay, great. So one of the questions, and Brent, maybe I don't know if you want to touch on this one, but is essential, I'm just going to read it here. Do essential organizations need to treat, so there's an essential, it's a healthcare business. The individual goes and gets an excuse from their physician. They treat it as the kind of the Family Medical Leave Act, and they're considered protected, so that when they decide to return to work, are they required to return them to the same role?
I don't know. I did read something on that, and I'm not sure. I didn't think that healthcare businesses were covered by the expanded act, number one. I thought that they were excluded from that. So if you're a healthcare organization or healthcare, I can't remember what the definition is, and they didn't define it very good either, by the way. But so I don't know that the FFCRA applies to hospitals, doctors' offices that are open, not the elective places. And then the second part of the question was whether or not they have to allow them to return. I think that in the act, and again, there's a lot of reading here, but I think in the act there's some employee limit where you then, if it's FFCRA leave, you do not have to return them if you can't. So under the FMLA, that doesn't really matter. But if in the end the job has been eliminated because of the downturn, and you just don't have the work anymore because of COVID-19, because you've been partially shut down, there may be an exception to the requirement that you return them to work afterwards. But I don't know that for sure. Again, it's one of those things you'd have to research to be sure of. And I'd like to, that's another thing, there's a lot of stuff on the internet right now. And trust me when I say that a lot of it isn't right. There's a lot of real kind of open-ended summaries of these laws, and unless you read the entire act, the CARES Act and the FFCRA, you're not going to know whether or not what you're getting on the internet's right or not. There are a lot of good law firms that have done COVID-19 summaries, and typically those are right, but there's a lot of other stuff that I was reading that, it just doesn't go deep enough, or it's wrong. So people need to be careful of that also.
Mike, anything? Okay. And I've seen some of our lenders out there. So Rachel, you might need to unmute somebody if they want to jump in on, maybe Wood or somebody, but I'll touch with this question here. So there's an independent contractor. So they're just a 1099 individual. Would they be eligible for the payment or payroll protection program and unemployment benefits at the same time?
Mike?
Good question. I'm writing that one down, and I will find that out and send it back out to Rachel. I am not sure if they would be eligible at the same time. I'm pretty sure that the earnings from the PPP would be countable towards unemployment, but I will find that out and share that back out with Rachel.
Great. Thank you. Any other questions out there if somebody has one? Otherwise, we'll wrap it up. Not seeing any. Well, oh, Della's back.
I'm back.
Okay.
Sorry about that. I've been fighting a little bit of a tickle, so working from home, right? I'm back. So I want to thank Mike and Brent and Rachel and Jeremy for helping us with today's conference. I also want everyone to know that this has been recorded and it will be on the greaterburlington.com website shortly so that you can revisit it or you can share it. If you have other questions, please feel free to continue to put them in the chat box as we're wrapping up, and or send an email to anyone on the GBB team, and we will work to try to get you connected to the right resource to help answer those questions. Lastly, we will be pushing out a survey. We'd like your feedback and comments so that we can determine how to best be of help to you in the weeks ahead, including potentially additional conferences like this one online. Thank you, everyone. Happy Easter weekend. Stay safe, and we'll see you again soon.